Hi everyone. So the I wanted to start now. Governor. Governor. Okay. So one Article 153, there shall be a governor of any state. The same person cannot be appointed as a governor for two or more states. Same person can be appointed as a governor of two or more states. Executive power of the state and executive power of the state is vested in the governor. Appointment of the governor of the state appoints by the president. And the term of office of governor, the governor hold office during the pleasure of president. Governor may resign his office by addressing his resignation to the president, and governor shall hold office for the term of 5 years and date of which entered upon the office until his successor enters upon his office regardless of expiration of the term. Qualification of the governor are he is citizen of India and completed the age of 35 year, and condition for the governor office are a member of either house of parliament, member of house of legislature uh, uh, of the state, and he must, like, if he is in that position, then he shall never be a governor. He must vacate his seat in house before entering office of governor. Governor shall not hold any office of profit, and governor is entitled to emoluments and allowances and privileges as specified in second schedule, and emoluments and allowances of governor shall not be diminished during his term of office. Okay. And power of governor is the grant pardon, reprieve, respite, remission and punishment, and to suspend, remit and commute. And president may discharge the function of governor during the contingency. These are some governor's power. Now, council of ministers. So what are the council of ministers? Okay. Council of Minister. So there is a article 163, Council of Minister to aid and advise to the governor. Council of Minister with the chief minister at the head, aid and advice for the governor in exercising of his functions. Validity of the governor acts under the discretionary power cannot be questioned. Governor has the more discretionary powers in that. Validity of the governor act under the discretionary power, and advice tendered by the ministers to the governor cannot be inquired into any court. And now appointments, like 164 article is during the appointment of CM is appointed by the governor, and other minister appointed by the governor on the advice of the CM. Minister hold office during the pleasure of governor, and total number of minister in the state cannot exceed 15% of the total number. So 15% ceiling is given in that, and total members should be 12. Okay. Council of Ministers are collectively responsible to the legislative assembly, and if a minister is not a member of legislature of the state for any period of 6 consecutive months, cease to be a minister. The salary and allowances of minister are specified in the second schedule. So these all about the governor. Next is the Advocate General. Advocate General is the Articles 165. He appointed by the governor. His salary will be according to the governor. He works according to the pleasure of the governor, and he advised the government on the state on legal matters to perform the legal duties referred or assigned to him by the governor. So these are, and he should be a like judge of high court. His qualification is like that. Now we are going to discuss about conduct of the government. So conduct. Okay. Conduct of the governor is 166. Conduct of the business of the government of a state. All executive function of the government of a state are taken by the name of governor. Okay. Order and other instrument made and executed in the name of governor cannot be questioned in any court. Duty of the chief minister is furnishing the information to the governor. CM duty is to furnishing the information, and it is the duty of the chief minister to communicate to the governor. To governor advice to require a minister to submit his decision on any matter which has not yet been considered, and all decision on administration affairs of the state, all proposal of the legislature. It is the duty of the chief minister upon governor call to furnish information relating to the administrative affair and relating to the legislative affair. So these are some article 166 and 167 regarding the work of the CM and governor. Okay, now the state legislature. Now we are going to discuss about the state legislature. How state legislature works. So article 168 provided constitution of legislature in state. There shall be a governor, plus a legislative assembly and a legislative council. Okay, abolition or creation of legislative council in the state, resolution has to be passed majority of the total membership of the assembly, like 2/3 majority should be there, and majority of not less than 2/3 of member of the assembly present and voting. Present plus voting should be there. Okay, it is the like abolition or creation of a legislative council that is given in that. So composition, article 170 is given the composition of legislative assembly. Legislative assembly of the state consists of not more than 500 members chosen by the election, direct election. So 500 members should be in the legislative assembly, not less than 60 members chosen by the direct election, and 60 members should be chosen by the direct election. Okay, and article 170 provides state are divided into territorial constitution to maintain the ratio between population and number of seats. So there is a population and number of seats also, so state will measure all that. Okay, and territorial constitution shall be readjusted after the completion of the census until the first census to be taken after 2026. So first census was taken in 2026. Seats may be readjusted on the basis of 1971 census. 1971 census is there, so seats may be readjusted according to that. Territorial constituency may be readjusted on the basis of 2001 census. Composition of the legislative council. The total number of member of legislative council shall not exceed 1/3 of member of legislative assembly. So legislative council should be 1/3 of total member of legislative assembly, shall in no case of less than 40. So minimum 40 member are given there. Okay, election of the member, 1/3 are elected by the electoral consisting the municipality, district boards and other local body. So now election is 1/3 from the municipality, district boards and local authority. Okay, and 1/12 by the graduates of university, 1/12 by the teachers, and 1/3 by the member of legislative assembly, and member of legislative assembly eligible not eligible for the membership in the council, and governor appoints remaining people like science, literature, cooperative movement and social service and art. So that was before that included nominated member. Now this clause has been closed by the parliament, like by the constitution, so this will never be added in that. Okay, now article 172. Article 172, duration of the state legislature. The legislature assembly can be dissolved. Legislative assembly has the term of 5 years. So 5-year meeting will be there, and duration of legislative assembly is 5 years. Duration may be extended by the parliament by law in case of emergency. If there is a emergency period in operation, then this can be extended. Parliament by law can extend the period not exceeding 1 year. So it may exceed only 1 year. Okay, and cannot extend beyond a period of 6 months. So it cannot be extended beyond the period of the 6 months after the cease of the proclamation. If there is a proclamation of the ceasing of extended duration, then there must be a period of 6 months towards there. So duration of legislative council. The legislative council shall not be subject to dissolution. Like the legislative council do not dissolve. Okay, and 1/3 of the member retired on the expiration of every 2 years. Okay, 1/3 will be every 2 years expires. Now article 173, qualification for the membership of the state legislature. So he is citizen of India. He is in the case of seat of legislative council not less than 30 years, and in the case of seat of legislative assembly 25 years. So he possesses such qualification as may prescribe in behalf of under any law made by parliament. Now article 174, what is describing? The governor shall summon each house of legislature to meet at such time and place he thinks fit to, and the time between the last sitting and first sitting of next session should not exceed 6 months, and governor may from time to time prorogue the house and dissolve the legislative assembly also. Now article 176. Article 176 talks about the governor address both the house of assembled together, governor address joint assembly, legislative assembly alone, and commencement of first session of each year and the first session after each general election. Now article 177. It talks about right of minister and advocate general as respect houses. So minister and advocate general has right to speak in the legislature, to take part in the proceeding, and advocate general is not entitled to vote. He can't go for the voting rights. And any joint sitting of the house, other house, any committee of legislature being in the member, so they can take proceeding in joint sitting and other house also and any committee also, but they can't be entitled for the voting rights. Like AG will never be entitled for the voting rights. Okay. Now officer of the state legislature, the officers. So 178 talks about the like speaker and deputy speaker of the legislative assembly. So 178, legislative assembly shall choose the speaker and deputy speaker. Vacation and resignation of and removal from the office of speaker and deputy speaker. Speaker or deputy speaker shall vacate his office if ceased to be a member of the legislative assembly, may any time by writing under his hand and address to the governor. And if such speaker, if such member is and the speaker to the speaker will give his resignation to the speaker and deputy speaker to the speaker. Okay, so may be removed from his office by the resolution of assembly passed by majority all of them. So there should be a majority resolution to vacation of their seats. Whenever the legislative assembly is dissolved, the speaker shall not vacate his office until immediately before his next meeting. So if there is a dissolution of legislative assembly, then speaker will never vacate his seats until the next meeting will be there. Now article 180 is speaking about power of deputy speaker or other person to perform the duty of the office or on act as a speaker. So while office of the speaker vacate, deputy speaker act as a speaker, governor may appoint another person for purpose in the absence of deputy speaker. Okay. Now article 181 it talks about the speaker or the speaker cannot preside while a resolution for his removal from office is under consideration. The speaker shall take part in the proceeding and he is entitled to vote only in the first instance. Only in the first instance he will part in the office. Okay, but not in the case of equality of vote. If there is a equality of vote, they will never take part in the office. So article 182, legislature council shall choose the speaker and deputy speaker. Vacation and resignation of removal from office of chairman and deputy chairman. Chairman or deputy chairman shall vacate his office if he ceases to be a member of legislative council. If such member is chairman or deputy chairman, if such member is deputy chairman to the chairman resign his office, may be removed from his office by the resolution of council passed by majority all of them member of council. So article 184 talks about the power of deputy chairman or other person to perform the duty of office if there is no chairman. While the office of chairman is vacant, deputy chairman act as a chairman. Governor may appoint another person for the purpose in the absence of deputy chairman. 185. Article 185 talks about the chairman or the deputy chairman cannot preside while a resolution for the removal from the office is under consideration. The chairman shall take part in the proceeding and the entitled to vote only in the first instant, but not in the case of equality of vote. So if there is a first instance, then proceeding, the chairman shall be part in the proceeding and entitled to the vote only in the first instant and not in the equality of the vote. He will never be vote in the equality of the vote. Okay, now conduct of business of legislature. So what are the conduct of business of legislature? Article 189 is given, all question at any sitting of the house shall be determined by majority of vote of member present and voting. And majority of vote will be there. Okay. So the chairman or speaker or person acting as a shall not vote in the first instance and can only exercise a casting vote. So there is a casting vote. In that they must be exercising the voting rights, otherwise they do not have any voting rights. In case of equality of votes, that casting vote will be in case of equality of vote. Okay, and the quorum to constitute a meeting is 1/10 of total member of the house or 10th member of house, whichever is greater. Chairman or speaker or person acting as such can either adjourn the house or suspend the meeting until the quorum. Okay. Now, disqualification of member in the state legislature. So Article 190 talking about the vacation of seats. No person shall be member of both the House of State legislature of two or more states. Okay. So if he is the member of the Legislative Assembly, he will never be a member of the Legislative Council. Or if he a member of a Legislative Assembly or Council, he not be member of the Parliament. So this is the clause 190 is telling about. Okay, the 191 disqualification for the members if he holds any office of profit, if he is unsound mind and stands so declared by the competent court, if he is a undischarged insolvent, if not a citizen of India, has voluntarily acquired the citizenship of the foreign state, in is under any acknowledgement of allegiance or adherence to the foreign state, and if he is disqualified under the 10th schedule. That is the disqualification. 192 Article 192 talks about decision on question as the disqualification of member. Disqualification of a member under Article 191 is referred for decision of a governor, and his decision is final. The governor shall obtain the opinion of Election Commission and act accordingly. So Election Commission will be there, and governor will act according to the Election Commission of India. And the decision on question as the disqualification of member is given in 191. So penalty for sitting and voting before making oath and affirmation under Article 188, or when not qualified or when disqualified. Penalty for 500 rupees to be recovered as a debt due to state. Okay. Now legislative procedure of the state. What are the legislative procedure of the state? Legislative procedures of the state. What are the legislative procedure of the state? Article 196 talks about provision as to introduction of passing a bill. So a bill may originate in either house of legislature of a state which has legislative council. A bill pending in the legislative of a state shall not lapse by reason of prorogation of the house, and a bill pending in the legislative council of the state which has not been passed by the legislative assembly shall not lapse on the dissolution of the assembly. A bill pending, like if there is a bill pending in the legislative council, that will never be lapsed if that is passing to legislative assembly. So this is the clause you should have been in the mind. A bill pending or passed in the legislative assembly of the state but pending in the legislative council shall lapse. If that bill is in legislative assembly, now it's going to pass to the legislative council, that then it may be lapsed. Okay. A bill passed by the legislative assembly of the state is transmitted to the legislative council. Now legislative council reject the bill, 3 months elapse without the bill being passed. So it can reject, it can take 3 months, pass the bill with amendment to which the legislative assembly does not agree. So Article 197 talks about the legislative assembly may pass the bill again in the same or in any subsequent session with the or without such amendments. Legislative assembly then transmit the bill as so passed in the legislative council. If after a bill passed the second time by the legislative assembly and transmitted to the legislative council, the bill is rejected, more than 1 month elapsed without the bill is being passed, or bill is passed with amendment to which the legislative assembly does not agree. So these are some fundamentals are given. The legislative council may reject the bill, may take the bill for 1 month elapsed without the bill being passed, or bill is passed with amendment to which the legislative assembly does not agree. So this can be given the powers to the legislative council, and legislative council pass the bill with amendment to which the legislative assembly does not agree. Okay, so both can pass the bill. Okay, and special procedure in respect of money bill, like a money bill shall not be introduced in legislative council. You should have mind in that. Okay, and legislative council shall within a period of 14 days return the bill to the legislative assembly with its recommendation. Legislative assembly may accept or reject all or any of the recommendation of legislative council. If legislative council does not return the bill to the legislative assembly within the 14 days, it shall be deemed to be have passed by the both of the houses. So 14 days ceiling given to the legislative council. Now bill in the legislature. Article 200 is providing us assent to the bill. Any bill passed by the legislature of the state is sent to the governor for his assent. Governor may assent to the bill, may return to the bill, not money bill. Governor cannot return the money bill or reserve the bill for the consideration of the president. So president's consideration is given here. A bill returned to the governor can be passed by the house with the without amendment. So pass is presented to the governor for assent. The governor shall not withhold assent thereof from. Governor shall reserve the bill for the consideration of president if they become law, so derogate powers of the high court. So bill reserved for the consideration. When a bill is reserved by the governor for a president, the president shall assent to the bill, direct the governor to return the bill to the house. Okay, the returned bill is considered by the house within the period of 6 months. So 6 months ceiling is given to the governor. If the bill is again passed by the house with the without amendment, it shall be presented again to the president for his reconsideration. So bill will go to the president for his consideration. Okay, so these are some provisions are given in the constitution. Now procedure in the financial matter in the legislature. So there is the similar what we read today in last video. Article 222 annual financial statement. Okay, every financial year the governor lay the annual financial statement before the legislature of the state. So the estimate of expenditure constitute expenditure charge on the consolidated fund of India, expenditure proposed to the made from the consolidated fund of India, emolument and the allowances of the governor. Okay, expenditure charge on consolidated fund of India is the emoluments and allowances of governor, salary and allowances of the chairman and deputy chairman of legislative council, speaker and deputy speaker of the legislative assembly, salary allowances of the judge and high court, and any sum required to satisfy judgment, decree and award any court or arbitrary tribunal. So procedure in the legislature with the respect to estimate expenditure charge upon the consolidated fund of India. 203 talks about the procedure in legislature with respect to the estimates. Shall not be submitted to the vote of legislative assembly, shall be discussed by the legislative assembly. So voting is never there, similar to the state. Center. Other expenditure charged from the consolidated fund of India are submitted in the form of demand for grants to the legislative assembly. Other form will be go in the form of demands and grants. House of People have power to assent or to refuse the assent. To assent any demand subject to a reduction of amount of specified therein. No demand for a grant shall be made except on the recommendation of the governor. Appropriation Bill is introduced. Now Article 204 is given. The Appropriation Bill is introduced for the appropriation of fund from the consolidated fund of India. So bill cannot be amended to vary the amount or alter the destination to vary the amount for any expenditure charge on consolidated fund of India. Article 205 is given the supplementary and additional and excess grant. The governor shall lay before the legislative assembly another statement for the excess grants and vote on credit. Article 206 is given the vote on account and vote on credit. Okay, the legislative assembly have power to make any grant in advance, to make the grant for meeting an unexpected demand upon magnitude of indefinite character of service, to make an exceptional grant which form no part of the current service of the any financial year. Okay, now procedure of legislature of the state. What are the procedure they are drawing in that time? So Article 208 rule of procedures, rules and procedures. It talks about the rule and procedure. So each house of legislature of state may make rules for the conduct of business. Business in the parliament shall be transacted in the official language. So Article 210, there was a Article 120, there is 210. It talks about the official language shall be Hindi, English or mother tongue. Any member who cannot adequate express himself in Hindi or in the English, he can go for the mother tongue. Article 211 is restriction on the discussion in the legislature of the state. No discussion shall take place in the legislature of state regarding the conduct of any judge of Supreme Court. Article 212 is talks about that validity of proceeding in the legislature cannot be questioned on the ground of irregularity of procedure, and no officer or member of the legislature shall be subjected to the jurisdiction of any court. Article 213. Article 213 talks about power of governor to promulgate ordinance. It's talk about the ordinance. Okay, so When both the houses of legislature of states is not in session, governor may promulgate ordinance in following circumstances. An ordinance promulgated under this article shall have the same force and effect as a act of legislature of the state. So, must let before the legislature of the state cease to operate the expiration of 6 weeks. So, 6 weeks ceilings is given if there is an assembly of the legislature of a state. Cease to operate if before the expiration of period as resolution disapproving it is passed by the legislative assembly, may be withdrawal at any time by the governor. Governor can withdraw this at any time. Okay, High Court. Now these are all about the